Good afternoon, dear colleagues, and welcome back to this second part of today's workshop. This session will contain a practical application of the principles and the process of the EUIPO mediation and ADR ecosystem as presented by the colleagues in the two previous sessions this morning. Mr. Sven Sturman, chairperson of the second Board of Appeal, and Mr. Gordon Humphreys, chairperson of the first and third Boards of Appeal of the EUIPO, who are both accredited mediators, will be the moderators of the workshop's case study. I also believe that you have received the documentation relevant to this case study, and this documentation will of course be the basis for the workshop. I will now pass the floor to Sven and Gordon. The floor is yours. Thank you.
Yeah, thank you very much, Kirsten, for your kind introduction, and good afternoon again to all of you. The idea of this 2 hours is a little bit to go through the different aspects we have seen and discussed already in the morning, as Kirsten has just explained. So we thought that first we will answer the still open question. Then I think we can also give you again the floor if you have any follow-up questions on the topics we've just discussed in the morning session. And then the idea is that Gordon will give a brief overview of the general facts of the case we have sent you. And then we would like to go through together with you through the confidential information. And there we will go step by step, and then we will analyze the case and to see which issues would need to be addressed by the mediator. And there we will again go through the entire process to all the different issues of the methodology, the different techniques to be used. And we would suggest to make it as interactive as possible. So we would like to do it with you. So we go paragraph by paragraph, and then would like to have your comments, what you think could be important in this information, which you find on the confidential sheet. So the idea is to make it as interactive as possible and to engage into a dialogue between all of us, if this is okay with you. Good. Then again, if you have questions, then prepare them, please. And there was one question on the facilitative and evaluative mediation techniques. I mean, Gordon will surely also give his view on that. My personal view is that we don't have, let's say, one technique here at the EUIPO which we follow. And I think here the key word again is flexibility. So I think it depends on the parties, on the process, if you are either more facilitative or more evaluative. It depends on what the parties want from you. It depends how active they are and how you guide the process. So even in the same mediation, you can at a certain point be more facilitative, but at the other point, at the later stage, earlier stage, you do much more in evaluative style. So again, I think it's flexibility, and for us, it's important that the mediators know the techniques for both styles so that they can use them in a specific point in the mediation. So again, here it's what the parties' needs are, what the process is about, and then the mediator needs to decide which style is more appropriate for the mediation. But I don't know, Gordon, if you agree with me.
Yeah, thanks, Sven. Yes, basically, I agree with you. I'd just add that, of course, the evaluative approach has to be taken with some caution. Often parties start out by the expectation that since the people, we're acting as mediators and we know about IP, particularly trademarks and designs, that they need to convince us of their case. They see us as the judges in a court or a tribunal. So first thing we always say is that we're not here to judge your case, and we're not here to give legal advice. Having said that, of course, there are some circumstances where they do need a bit of help with sort of the opinion on a particular matter. Now, we can do that. Actually, this goes back to something that Kirsten said in her initial introduction, which is expert determination. If the parties get blocked on, for example, the first case that I showed just before the break about the descriptive term in that overlaps in a trademark conflict, if one of them is in denial about what that means, it's possible that we can recommend to the parties that they seek an expert determination on the matter that they disagree about, a legal point, and there they get an actual opinion, a legal opinion. Probably wouldn't be appropriate for us to be so direct. I mean, we might say, are you convinced by this particular point, its descriptive character, and why are you so convinced that it is not descriptive, for instance? And we might seek to challenge it, so indirectly challenge it, get them to think about and give reasons for a particular matter, or we may just go if we could refer them to expert determination. And of course, there's the transformative school of mediation, which is essentially getting people to put themselves in the shoes of the other party. And I'd say that we pretty much switch between all these techniques at one or other point. Maybe, I mean, evaluative, we don't necessarily give a legal opinion, but we may give an indication of you know, where a problem might lie, or where you know, what we may even on occasion point them, say, are you aware of a particular case? We don't I've done that myself. I don't say what the case says or whether it supports them, or I would just say, are you aware of this latest judgment on this matter from the General Court or the Court of Justice, and then let them read it and draw their own conclusions. Transformative as well, you know, putting yourself in the shoes of the other party. Good technique as well.
Yeah, and I think what you raise an important point, because that happens quite frequently in our mediation, that the parties come to a point where then the legal question arises, what's the scope of the earlier mark, right? I mean, sometimes it is so difficult that you need to either give an opinion if the parties allows you to do, or you refer to expert determination, as Gordon has said. But it's very often that there is this legal question, and you can then try, of course, to desvinculate the legal issue and try to come back to the business issues. But very often, especially if you have the lawyers on the table, they will then still insist and say, yeah, okay, but my case is wonderful because your trademark is nothing. You have no scope. You have it's a completely crappy and descriptive trademark. There's no scope of protection. So it is actually, if you run the mediation, very often a very important and tricky point where you come to a deadlock, and then you need to see how you can overcome it. And you either do it as Gordon has just said. So you try to guide a little bit the parties, or you again try to focus more on the business side, which is not always a guarantee that this works. Or if you really see there's the deadlock, then I think you would need to suggest to the parties to refer that to an expert determination. Okay, do we have, yeah, there is another question here now. Can you read this, Gordon?
Okay, so thank you for your clarifications. As it was mentioned before, expert determination can be binding or non-binding. Do the parties decide on this matter, whether it is non-binding, or are there certain legally prescribed issues where expert determination is legally binding? Well, okay, I mean, I'll start off, and Sven, you come in and supplement or disagree with me if you if you think appropriate. Well, it's the parties that decide whether the expert determination is going to be binding or non-binding, and it's just a contractual arrangement. Essentially, the parties enter into an agreement that they will submit a particular matter for expert determination, and they also specify whether it will be binding or non-binding. Obviously, if it's binding, what we mean by that is it's contractually binding on them. And if it's non-binding, well, it's just an opinion which they take into consideration, but it doesn't mean that anybody has to follow it.
And maybe to add, Gordon, that here actually for the expert determination, we have, let's say, we offer our experts to the parties, but the parties can likewise choose an external expert. And so here we have clearly opened the door, and if the parties prefer to have an expert who's not a staff member of the EUIPO, that would be no problem.
Yeah.
Good. Do we have any further questions on the morning session on the issue we have discussed?
I cannot see any in the chat, so I think you could proceed with the case study.
Good.
Thank you.
Oh. Okay, Gordon, do you give a short introduction and then?
Yeah, in our case, we've got a company called Evelyn, which is a little Spanish company, husband and wife team, basically. And they're in the design business, and they've filed and obtained a registered community design for this heart-shaped device with a sort of 8 on its side, so the number 8 on its side. And they've obtained registration as a design for ornamentation for bags, belts, tableware, apparel, t-shirts, printed matter, including advertising. Okay, and they got that registration back in January 2016. On the other hand, we have Swanxi, which is a Chinese company, a fairly large Chinese company that has an earlier EU trademark, which has a heart-shaped device in the center, and arguably a number 8 that interlocks. There's of course some argument between the parties as to what the designs actually portray, and this trademark covers jewelry and precious metals in class 14. It covers leather and imitation of leather, including bags in class 18, textiles in class 24, various the whole range of clothing, footwear, and headwear in class 25, and lace embroidery and ribbons and braids, etc., in class 26, and finally in class 35, advertising, business management, retail and wholesale services for all the goods that have been mentioned previously. So the problem is that Swanxi, the Chinese company, is unhappy about Evelyn's registered community design, which it believes, and so it's initiated an invalidity action against that design based on this earlier trade. And it says, the invalidity applicant says that it claims that its design has been, or its trademark, sorry, has been put onto jewelry that's been disclosed in at a major trade fair in China back in 2015. And it also says that back in 2015, so before it was actually, well before the registration of the community design that it's seeking to invalidate, that it also sent various goods, t-shirts, to a client in Munich, and that it had a catalogue in 2017 and invoices from 2016 in which various jewelry items appeared that bear its trademark, and also that a T-shirt that it sent, T-shirts that it sent from China to Germany. So it has quite a history now. What's happened is at the first instance of the EUIPO, the invalidity division has decided that the community design is confusingly similar to the earlier trademark. Now, bear in mind that when a European trademark, an earlier European trademark, comes into conflict with a design, it's possible, if there's a claim of that there's this conflict, then the rules of likelihood of confusion will apply. So it's as if in the EU system, the community design is treated as if it were a trademark in some ways. Okay, so this has resulted in the invalidity division saying that this design is confusingly similar to Svansch's trademark, and therefore that it should be invalidated for that reason. Now, what's subsequently happened is that Evelyn has appealed that decision to the Boards of Appeal, and claims that there was a violation of the duty to state reason, because there wasn't a proper analysis of the likelihood of confusion, and that for various reasons this contested decision should be annulled. It also claims bad faith, that the filing of the registered community design was actually done in bad faith. Okay, so that's where we are at the moment. And as Sven said, there's some confidential information which adds to that, which will tell you the role of the lawyers and the owners and all the other people that are listed on this sheet here. Sven.
Okay, thank you, Gordon. I mean, what we do here at the EUIPO Boards of Appeal is we analyze all our cases to see if a specific case is actually better fit, or is more suitable for an ADR procedure rather than taking a decision. And this is done in context of our case management system we have established here at the Boards of Appeal. Yeah, so we have actually not all the judges, the members, the judges of the Boards of Appeal are trained mediators. Some are, as Gordon and I, for example, and some others, but all of them has received training in order to be able to identify cases which can then be suggested for mediation, because this specific case it was suggested by the rapporteur. And for example, one of the important indicators, factors where the judge, the member would say, look, I think this case is more suitable for mediation, is if we see it in the exchange of arguments and documentation, if we see that there are many parallel disputes pending between the same parties, then this is a strong, let's say, hint to actually evaluate with the parties and the lawyers, if not an ADR process such as mediation is more suitable. Because here the advantage is, and we said this already in the morning, you can include all parallel disputes pending between the same parties in one mediation. So for example, in this case, it's pending at the Boards of Appeal, but had the parties parallel infringement proceedings, and we have that here, then we can offer the parties to include these infringement proceedings into the mediation. So we only need one, let's say, a starting case at the Boards of Appeal. But from that moment on, we can include all pending disputes between the parties. They can be pending in our office, they can be pending in national offices, in national courts, and not only EU, but international wide. So I remember, Gordon, we did a case together many years ago where we settled up to 30 parallel cases in one mediation. So I think this is very important. So again, the case management system we have set up here at the Boards of Appeal is that everybody who drafts decisions, when they analyze the file, that they can actually understand and see and evaluate if a decision is maybe not so useful, not so effective for the parties, but rather an ADR process such as mediation would better serve the parties to come to a global solution, because that's the key word here, the global solution. Because what does it help if you take a decision in one case and then between the same parties and often the same trademarks or very similar trademarks, you have cases pending in 10 other jurisdictions, and you need to wait until you get a final decision of these jurisdictions before you can actually go ahead with your business. So that's why we believe that here these cases are particularly suitable for mediation, for ADR, in order to offer the parties to find a global settlement, global solution to their dispute. But of course, it goes without saying that no party is obliged to include all the pending disputes. I remember I had a case where the parties actually had some parallel disputes, but they clearly said, no, with this mediation, we only want to settle this specific dispute pending at your Boards of Appeal, but not including the other ones. So that's, of course, under the discretion of the parties. But again, that's the philosophy behind of our ADR service, to give the parties the possibility to find effective dispute resolution towards a alternative dispute resolution. I don't know, do you have any questions on the way how we actually initiate the cases? So here, the rapporteur, again, the judge, the reporting judge, member of the Boards of Appeal, he or she sent the communication to the parties, explained in the communication briefly why he or she thinks that the case would be suitable for mediation. And then we give the parties a 2 months deadline to either agree or disagree to engage into mediation or conciliation if they prefer. And then within these 2 months, they would be contacted by one of our mediators just to offer them further information, to explain the process, so that they can actually take an informed decision. And there, the person who contacts the parties will actually highlight and explain again the possibility that you can include all the parallel disputes pending between the same parties. And even if it's either regarding other IP rights, because very often, you have a trademark dispute, but at the time you have a design dispute, if we have here, or we have a trademark dispute and then you have domain name disputes, because that very often when the parties try to register a trademark, they also register a domain name. So if there is a conflict over the trademark or the domain, vice versa, there's a conflict then with the other right. So all these things can be included into one mediation process. Do you have any questions so far on this way how we initiate, or any comments or remarks?
Don't see any at the moment.
Okay.
Sven, maybe just to say that we had a question earlier on about whether all this mediation is, if it takes too long, whether we're going to actually end up being more expensive than just if we did the normal process. So I was just thinking, one of the things that I always bear in mind in these initial contacts with the lawyers especially is that it's billable time. And so one of these initial contacts, my first question will be, how long would you like to make the first exploratory meeting? I will usually propose, say, an hour and a half, and I will ask them, is that okay? Because I'm very aware that billable time is running, and we have to make it count in the contacts, so we don't waste any time, or there's no perception that we're wasting any time. I think that's something to bear in mind, that parties are conscious that this is costing the money, and therefore we have to be as well.
Yeah, absolutely. I fully agree with you, Gordon. And on the cost side, I mean, it's true. In mediation, you have to pay the lawyers, and they probably charge you on an hour basis. But I think when you talk about the cost, you have to also, again, as always in mediation, take the overall picture, the global picture, because it's not only that you pay the lawyer's cost and these, but you have to see what can you save on the other hand if you manage even to set a straightforward case. Because if a case is pending for a long time in your business, it's not only that you have costs for lawyers, you have legal fees, court fees, but it's also the indirect cost. There's always somebody who's busy with this conflict, who has to manage the conflict, the conflict also at the company stage. Yeah, so I think it's not only because we quickly say there is cost for the lawyers, there's cost for the court or for the mediation. Yes, that's true. But on the other hand, I think if you have the possibility to settle a complex dispute, and again, also in a relatively simple one, and you avoid, that was Kasia saying, I fully agree with her, what she said, that you get legal certainty quite quickly. Yeah, and then actually the conflict is out of your company domain, yeah, because there's no one else. You have settled it, it's done. Yeah, of course, under the presumption that this agreement will then also be respected by the party. But let's assume this, then actually you can focus again on new things in your business. And that I think is quite important, especially if you talk about bigger companies. They have a lot of conflicts, and that keep a lot of people in their companies busy for quite a lot of time of their working hours. So I think overall you need to take the global picture and balance the different issues also as regards the cost.
Absolutely. So Sven, going back to the confidential instructions, I mean, I think the point here is this is information. We were talking, Kasia was talking about the exploration. So, sorry, it was Sophie that was talking about the exploration phase. And all this information that we've got here and which we've helpfully got in front of us, in reality, we would have to get a lot of this out of the parties. And that would be what we would be doing in the exploration phase. And, you know, just tying it in with what I said about these initial contacts. I mean, now that everything has gone online and we're with Zoom, obviously what we'll tend to do is set up an initial meeting with the lawyer, possibly with the client if that's, you know, to do both together. But if not, then there'll be a second meeting with the client. And we would try and already start a bit the exploration phase, so that when we come to the day of the mediation, we've got a lot of facts in our possession, and we have an idea where the common ground might be, so that we very quickly move to the negotiating phase with offers. And we would also, in this initial stage, so if we had this Chinese party and the Spanish party, we would be asking them in our conversations, so, you know, have you any ideas how this matter might settle? What do you think a settlement would look like? What are you looking for? And what ideas have you got for settlement? So that, and also not having just one idea, because we'll say, yes, you might want idea A as your settlement, but what if you don't get A? Do you have a B plan? And so that they come with a range of ideas. They come already with clauses they might want in the settlement agreement, even though we're only at the initial stages, so that it can accelerate, hopefully, the process and make things a lot easier.
Yeah, exactly, Gordon. It's a very important point you're raising, and this falls under the term preparation. And I think also to make the mediation as effective as possible, again, in the view also of the cost of the lawyers, what you have said is absolutely essential. I think the mediator, or let's say that's at least what we ask our mediators to do, and what Gordon and I do in every mediation, we spend quite a time not only in reading the case file, which we have in our system, but also try to find as much as information possible on internet. And not only about the company, but also about the persons involved, the person who will attend the the mediation, because you can get a very valuable information if you read CVs, if you see the interests of the people, their professional background, which actually can help you in a specific situation when the mediation is deadlocked. I remember, Gordon, the case we had together, there was a lawyer who was not easy to handle, and then actually we found out that in his previous career, he was a professional gardener. Yeah. So what information did that give for us? I mean, that gave us information that he's a quite creative person. And then the other hand, there was a lawyer who was a very, very, let's say, very technical one, a very financial guided person. For him, it was numbers and numbers and numbers. So the mediation came actually to a situation where we had a kind of deadlock. So we stopped the mediation, and then we addressed in individual email to each of them to try to get them into the process, to the mediation process again. And then for this person who was the gardener, the former gardener, who we thought was a very creative person, we used an email, we used very creative wording, we used a different language as we used for the person, where we knew that he was a business and financial person, and where we focused all the time on the effectiveness and the financial advantages of a global settlement. So again, preparation is crucial. I think we need to find out the most information we can get to get a picture, to overall picture of the companies. Because also don't forget, if you're sitting in the mediation, and again, as you have raised this point on the costs of the mediation, if you start asking basic questions what the clients are doing, they will immediately say, but have you not investigated a little bit what we're doing? So I think it's also kind of let's say, being taken seriously by the parties. But because if you start the mediation, you can say directly, look, I've seen that your business is this and this and this. And if that's true, and what else are you doing? Have I understand correctly? Then I think you are setting the scene in a different manner, because then you actually create confidentiality amongst the parties, because they will see that you as a mediator understand what their business is. Yeah. So again, the preparation process, I think, is very, very important in order to set the scene for the actual mediation.
Yeah. So here, Sven, I mean, what we would have done is we would have first of all gone on Google and looked up the lawyers. So Maria Gomez for Evelyn, and Thomas Lange for the Chinese company, and had a look at their profiles. What sort of people are they? Where have they studied? What sort of lawyers are they likely to be? Very technical ones, as Sven just said. Are they going to be ones where they're very much anchored in all the legal problems, and it's very difficult to get them out of that, and therefore you're going to have to address the legal issues, or else they're going to feel excluded from the mediation, and even somewhat frustrated. So you're thinking about strategies that you might have. Maybe Thomas Lange is very proud of his CV and the long studies that he's done with his year in America, getting his LLM, and you can make sure that when you're engaging in a dialogue with Thomas Lange, that you pay him the due respect that he's going to want and demand, and you don't antagonize him. You want him as on your side, and these are techniques. And obviously, we do the same thing with the people. The director Leo Lee and his wife Eva will go on and look, and we'll see a bit in the facts here about things. We see that they have an interest in China, obviously, so we might want to think about how we're going to use that. All this information, you can get a lot of it, as Sven said at the beginning, and this is what we would be doing at the outset.
Yes, and now let's ask them a question. So let's be a bit interactive here. We have had a lot of talking, and I know it's Friday afternoon, but it's exactly the reason why. Look, we are here in a very confidential environment, so there's nothing right and wrong. But let's try to work out this together. So what Gordon and I have said now, to find out the information, where do you see the risk here? Do you think this is the right approach? So we investigate everybody, so we know about the people, we know their hobbies, we know their professional career. Do you think that, is there any risk, or do you think this is the right approach? What do you think? If you can also write in the chat, if it's no problem. If you prefer writing in the chat, just write in the chat. But if you, or just what the right approach, okay? Someone else. Nobody sees the risk here.
Human face always matters, right?
Absolutely, yeah. Absolutely. But what exactly? But what is the risk? What is the risk with this? With the human face, that you see somebody and you investigate too much? Isn't there? Don't you see any risk there? Especially for the mediator.
Yeah.
And this is something you need to know. This is super important because it's dangerous. Because I've done, when I started, I did it like this. And then I actually had an experience where I thought, oh, this is good, but it's risky. You need to be careful. What could be the risk here with this approach Gorn and I have suggested to do? So the risk, yeah, impartiality. Yes. Absolutely. Who has said this? Can you explain this a little bit, please? And you can, of course, we have translation here. You speak in Georgian and then it's translated. Yeah, you don't have to speak in English. It's no problem. So that's the point. What do you mean with impartiality? What's the risk here? Yeah, because if you have a lot of information and then you go into the meetings, of course, all this information makes you that you're kind of biased, or there's a risk at least. Yeah, because if I think, okay, this person is the businessman, and this person is the, we need now the translator to translate this, please, yeah, into English.
Could one of the interpreters please give us the translation of this into English? Maybe in the meantime, Sven, what I would just say is there's also a second risk, and that is stalking, right? You know what a stalker is, that somebody, not a very nice word in English. And there's a fine line between doing investigation on people and stalking their private affairs. So we obviously, if you use this information, you have to use it in a very subtle way and not appear to have been stalking somebody, which will be counterproductive because it will give them a negative image that you were investigating. You know, if you were looking at whether they were in the badminton club and play tennis on a Sunday and their Facebook account, they might not like it.
So. And I think it's very easy. The information is only for us. You would never tell the client, look, I have investigated the internet, what you're doing or what the CV is. It's just to get that you get a little bit of an idea which personalities you can expect to be in the mediation. But then, of course, once you are starting, you need to completely keep this out, and you need to give a fresh start. You need to have it in your mind in case you need it, but you need to be absolutely impartial again, as you have correctly said, when you start the mediation, because you might be surprised, even the one who seems to be the tough business person, only looking at numbers, is then a super creative person. Yeah, so you have to be careful that you don't classify them incorrectly. That's very important. Yeah.
Yeah, and then we've got the translation now. So it's not to get seduced and not to get sympathies, which I think is about the bias. I do the same, even though I'm not a mediator. I always try to find a picture of our potential client or clients. Yeah, I think that's something that humans.
And of course, don't forget, I mean, we are all human beings. There are always persons you feel closer to, you like them more. I mean, this is unavoidable. Important is that you know this, that you know that you have this tendency, and that once you know it, you say, okay, this person is not the one I would now go out and have a beer with or coffee or whatever. But you need them to say, okay, this is now a business mediation, and I need to be professional, and I just need to give these people the same chance. I need to be absolutely impartial. And even because they will say things you don't like, or you don't agree with. But again, you have to be very careful and not falling. And people will this even use on purpose, because people are very clever. They use this also on purpose against you to actually challenge your impartiality. Now that's very important. So you need to try to be always take a step backwards and then just give it a fresh view and an impartial view as impartial as possible. And if you think, and if they even address your impartiality, that they say, look, I think you are now not impartial any longer, then it's very important not just to ignore it. You need immediately to take this, because I have seen in mediations, in mock mediations, when we train new mediators, that they were challenged and they was said that, look, we perceive you as not being impartial any longer, and they just ignored it. So that's very important. Whenever you have this situation, and even if you feel that you have been acted in a way which is not impartial, I think, in my personal opinion, the best way out of this is to be transparent, to be honest, and address this, and then leave it for the parties to decide if they want to stay with you or not.
Yeah.
Yeah, exactly. This is
okay.
For the translation. This is the point. Okay,
Yeah.
Gordon, maybe I have just one question again for you. Why do you think that this case Gordon has presented and we have sent to you is suitable for mediation? One of the issues we said, do you have parallel disputes here? But why do you think the judge thought that this case is relevant and interesting for mediation, apart from the fact that you might have parallel disputes and then you could settle a more complex case? But what is interesting in that case which makes it suitable for mediation? Do you have any ideas? Again, just write it in the chat or.
May I jump in?
Yes, please.
Please, yeah.
Okay, I believe there are lots of issues in this case that makes it suitable for mediation. Firstly, I would start with business interests. Also the division of geographical markets, and also the division between goods and services they produce. I believe there's a room for a negotiation because there's a lot of geographical areas which does not coincide. So geographically, they operate on different markets, and also the goods are kind of different as well. So there's a lot of room, as I said, and also the business interests, what they plan in the future. As I remember, one company has an interest to explore more and make a research in the field of artificial leather, and the other one has the same interest of entering that market. So there could be this could be another area for them to maybe explore some common interests. Well, I wouldn't jump into conclusions, but I would have this question for myself. Maybe there's something they can come up as a team, or anything else. And and also the human side of the case, which is that the family connections, if I remember correctly, and also the parties don't want to make each other upset, don't want to hurt each other. So there's also the human side besides the business interests.
Yes, I think you have summarized it in a perfect way. Because and I think in particular the human factor here is definitely an issue. And if the parties, and you will see it, I mean, you all work with case files, so we see it sometimes that even the lawyers, if they start to argue on the legal side, and if you see that they then swift to actually these human issues, I think this is a strong indication that there's something which could be, let's say, at least try to be settled with the mediation. Okay, any further comments? Thank you very much for this intervention. That was great. Good.
Yeah.
Then shall we start maybe with the confidential information, and we go one by one?
Yes.
Okay, shall we start with Evaline?
Yes, that's the part one. Yeah.
Okay. You go on the first comment.
Okay, so I mean, obviously, we've got here the parties Evelyn Accessorios, which is, as I said, a small, medium-sized enterprise. It's a husband and wife team comprised of Leo Lee and his wife Eva Hernandez, and they're both from Alicante, Spain, by some strange coincidence. Well, she is, and he is originally Chinese, and they provide bags and belts. So they manufacture bags and belts, and they do this both retail and wholesale level. And they have their own store in Alicante, and they supply one of the biggest department store in Alicante as well, or in Spain even, El Corte Inglés, and they supply a department store in Portugal and one in London. So they're in three. We see already that their interests are Spain, Portugal, and London, the interests that we know about. And of course, we would have to ask if there were any others. And if, as we continue, we find that they also do some freelance work for non-branded goods, bags and belts, for clients in the USA. So they're also interested in the USA. So as the lady that intervened just now said, obviously there's some territorial aspects which we've got to wake up to. We've got to say, okay, these are the territories, and then we would check with them whether there are any more territories, because these are the territories we know that they're already operating in, but do they have plans to operate in any more territories, for example? We'll see a bit later that they're also interested in China. So what we know from this is that it's a small company. So we've got to, there may be an imbalance of power issue here in the mediation. We have to be aware of that maybe the other company is much larger. Maybe they're going to come with, you know, like first division lawyers, whereas this company comes with third division lawyers. You have this sort of imbalance as well. Or maybe, you know, they're just things that we have to be aware of. But we already have a certain amount of information about the kind of company it is. It's family, so we know that every decision here. Well, let me throw this question out to the floor. Knowing that it's a husband and wife team, what does that tell us about the decision making of this company? What could anybody give us their thoughts on that, either in the chat or by taking the microphone? And as we said before, you can speak in Georgian and we get a translation into English to understand what you're saying. It's no problem.
I believe even in the team of husband and wife, they have to reach an agreement. So there's not a single decision maker in the team of a family-owned company.
Yes, I think that's exactly it. That you're going to need both of them at the mediation, and both of them making sure that they're happy with everything that's being discussed and any decisions that are taken in that mediation.
And I think, yeah, Gordon, if you allow me, this is a very important point you're raising, and I think this would be probably something to be discussed with them before the mediation, because here you need to know, are both participating at the mediation meeting as such, or is only one coming? Yeah, because as you has just rightly said, somebody from you, that they would be probably always taking the decisions together. So it's very important to address the issue of who has the power, who's attending the meeting, and if both attending, then of course it's easier. But for example, if only she or he attended the meeting, then you would need to address the question, okay, what do you have the authorization to settle, to take decisions, or would you need to confirm that always with your partner? And as Gordon said in the morning session, in this case, it would be very important and to ask this person to be available. Yeah, because I think there's nothing worse in a mediation when you come after at the end of the day, after following an exhaustive negotiation time, that then somebody says, oh yeah, that's very nice, I like it, but I need to check this first with my superiors or with my partner, whatever. Yeah, and this is very frustrating for the other party. So this needs to be tackled from the very beginning of the mediation. I would say even before the mediation process, who is attending in the mediation and who has the authorization to take decisions. And if they don't have it, who can somebody be contacted or not? And if it's not possible, this of course happens. I mean, not everybody is ready and is available. And also don't forget the difference in time zones. Yeah, you have sometimes in the mediations. And then of course you need to openly address this with the other party. So the other party needs to know, okay, there's somebody coming to the mediation who can negotiate on behalf of someone else, who has a certain degree of authorization, but maybe have also some limits. And maybe this person cannot immediately confirm with the decision taker of the company how far he or she can go. Now, all this needs to be addressed before the mediation so that there are no unpleasant surprises during the process. That's, I think, very, very important.
Yeah, and maybe I'd just say, going back to that question about evaluative mediation, that one of the things I would do in this situation is I would strongly recommend that both of them, if it at all possible, that both of them attend the mediation. It's going to be much better if they're there together.
Yeah, absolutely.
Okay, Sven.
Yeah, before we go to the next issue here, look, if this were real mediation, Gordon and I, and let's assume that you are the parties sitting there, we do an online mediation, Gordon and I do a co-mediation, so we would have started, let's say, introducing the mediation process. We would have explained to you the principles of mediation, characteristics, the flexibility, confidentiality, all what we discussed in the morning. And then in the specific point, we are sitting together in these now virtual mediation room. And then Gordon and I, as the mediators, we have to take a decision first. Do we start with a joint session, all of us together, or do we go directly into private sessions, caucuses? And if so, with whom do we start? So what would be for you now the criteria to decide who of these persons sitting at the table you would give first the floor, either in the joint session, or let's make two questions. So first, would you start with a joint session, or would you go directly into caucuses, into private rooms to discuss with the parties, or would you? And then the second question is, with whom would you start? What would be your criteria to say, okay, I start with the Evalin accessoires, or I start with the Chinese company? What would be your criteria? How would you, if you know the mediator, how would you do it? So first question, would you do a joint session first, or would you do directly private sessions? Any views?
We got an answer first.
Yeah.
Discuss the matter separately.
Okay, why? So you would go immediately, you would explain the process and then say, okay, let's go now into private sessions. Good, okay. But what would be, in which situation would you do it? What would be your reason? What could be a good reason to do this, to follow this approach? So for example, imagine that you have, and you know already that there is huge tension between the parties, yeah, because it's a highly even emotional aspects coming in, and you know, and you maybe even see in the first meeting that there are high tension, high emotions, and then of course it might be that you first, or let's say that you immediately decide to go into private rooms, into private sessions with the parties, yeah, in order to cool down a little bit the situation. On the other hand, if, for example, you see that this is purely business and people are really reasonable, are relatively easy, then I think you could also decide to actually do first a round of common sessions. Yeah? So you actually start discussing again so that everybody can hear the views of the other person and actually also understand the business, because I would always start exploring, understanding what's the business of each person. And that's also helpful then if the other party can listen. Yeah, because sometimes here, and you have said it already when we asked you why this case is suitable, because then somebody might even say, yeah, and I want to do this in the future, but I need support here. So that actually if the other party listens, it can be very helpful. But you're right, it can also be sometimes more or be more effective if you directly go into private session with this. In particular, if the emotions are very high. To sort out what is painful for the party, yes. I mean, this definitely you can do only in the private sessions, yes. But I think you need to go step by step. The first part is the exploration phase. So you need to understand first what's the business of each person and what's the conflict exactly about. Yeah, and I think here I always say what you need to show is curiosity. You just need, look, imagine you're sitting with some friends or your family and you're discussing a matter or even another conflict, and you really want to understand what had happened. Yeah, and also read between the lines. If then somebody said, "Oh, I was extremely upset," okay, and then the mediators, and when we train them, often say, "Oh, okay, you were upset. Okay, good," and then they ask the next question. No, if you hear words, "I was angry, I was upset, I was disappointed," all these things, then you need to ask, "Okay, that's interesting. Could you explain me why you feel upset or angry or disappointed? What happened exactly?" So you really need to dig into all this information and not just stop, because very often you ask a question, people answer, and then you go to the next question. That's not the way the mediator should do it. You should always try to do follow-up question and then really try to go deeper and deeper and deeper and deeper to really understand the person, the issue. And you know this famous triangle board. What you remember, you have a personal issue, you have a factual issue, and you have an emotional issue. And this you can find out when you really do these follow-up questions. And then you reconfirm if you have understand correctly. Okay, good. With whom would you start? With Evelyn or with Suan Shi? So imagine you ask me, I'm Evelyn, and you ask me, you said, okay, Sven, would you like to start? And then what would Gordon maybe do? Gordon, what would you say? Now you are not so nice. Why Sven and not me?
Yeah, why?
And I mean, look, it's not a joke. This happens. When you as media, you need to be ready. That might be that Gordon said, okay, why Sven and not me? I would like to start. So what would you do in this situation? Follow the chronology, maybe. That's a good point. I mean, that's also very easy. You say, look, this is the appellant or this is the opponent. You find the opposition. I would like you to invite to give the first statement. And usually people accept that immediately, because if there is not a big issue behind, then they say, okay, that's fine. Yeah, but be aware of this situation, and also when you decided, have a good argument ready if the other party challenged you and said, why she or he and not me? Yeah, but again, I think this chronology is a good argument.
Yeah.
Okay, good. Then coming back to the confidentiality effect. So this is something which we would need to explore with the party. So we need to ask a lot of questions to understand the business of Evelyn. Yeah, so we need to show some curiosity. We need to really dig into the information and to find out what's really their business about, what their interest. And here, again, and this is also part of the exploration, to really identify the interests which lay behind the positions. Now, we have mentioned that already in the morning, but I'm not sure, is this totally clear for everybody what's the difference between position and interest is? In my personal view, this is super important for mediation. And this is one of the big differences between court procedures and in particular negotiations and mediation. Because in negotiation, you usually, not always, you usually negotiate positions, but not necessarily interest. But the main focus in mediation, and this is one of the great advantages, is that you actually mediate on and try then to negotiate on interest. And that's the issue, because you may have different positions, but you have the same interest. And once you have identified the same interest, you will see that parties then say, oh, that's true, we have the same interest. So let's find out now how we can settle these common interests on the basis of the positions we have. So is it clear to everyone the difference between interest and position? So very briefly, so it's clear. Yeah. So interest is the motivator. What motivates me to take a position? So why do I file an opposition? What's the motivation? If I say, okay, I want to sue this person, I want to file an opposition against that trademark. So what is the motivation behind? That's the interest. Okay, good. And here in this case, in Evalin, obviously we need to try to find out and see what the real interest of the Evalin company and the Leo Lee and Miss Eva Hernandez is. Okay, Gordon, then you continue.
Yeah, I mean, I think here, then moving on, we see that Evelyn, she's married to a Chinese gentleman, Leo. She's passionate about China. She studied Chinese and she studied Chinese in London. So already this information might seem like it's not important, but it's going to tell us something about what her likely interests are. She's likely to be very interested in everything to do with China, and she's likely to want to combine her personal interests with her commercial interests to make sure that she does business in China. And indeed, we see in the next paragraph that that's exactly what she wants to do. She wants to, both she and her husband, obviously he's Chinese, so he has an interest in China. They want to set up production in China. They're looking for outlets in China, and they're very interested in the Chinese market. And also we see that because Evelyn studied in London, and we've just heard before that she does business with a department store in London, that's also part of her interests. She's trying to, like most of us, combine her personal interests with her business interests as much as possible. And the fact that she's Spanish, obviously she's interested in Spain. So we already have some information here that's likely to be important. We can also see, having noted all this interest in China, we will need to compare that to the interests of the other party, which we'll do in a minute, but we just make a mental note of all this for the time being, so that we're sure to check out whether there are any overlapping interests, because this goes to the issue we were discussing this earlier on in the day about making the pie bigger. Because if there are overlapping interests, maybe there's some room for them cooperating together, and maybe there are opportunities here. It's, you know, out of every adversity, there is also an opportunity there. You know, some people say one door closes, another one opens. You have to be looking for the open door, and you have to help guide the parties. That's your role as a mediator, is to help guide them through that open door and find those opportunities. Okay, so she has also a knowledge of, profound knowledge of the bags and belt market. And as we said before, she's looking at the possibility of making luxury imitation leather goods from vegan leather. And she believes that this has environmental benefits because it's vegan leather that's environmentally friendly, and that there's a potential market for all these bags and belts made out of vegan leather. So again, this is all about interests. These are business interests. They're also personal ones as well, because she's a bit of an environmentalist. But they're business interests that we're going to need to see if any of them can coincide with the other party, and we're going to have to see if there's any possibility, even if they don't coincide, whether there's a possibility of them coexisting side by side. Okay.
Gordon, if you allow me, because in this, I think there is another, in this context you are talking, I think there is another important information, which is in the third paragraph, where they said that the common business, the production in Spain, is now not profitable.
Yes.
Yeah? I mean, this gives you a very important information, because she wants to invest further in the vegan area. Yeah, and she wants to she's very innovative as well, but at the same time, you can already see here there must be an issue in financial issues, and a financial issue here for them. So when you hear that somebody said, "Oh, my company is not very profitable, and it doesn't make a lot of gainings and benefits," then I think you need to explore this very carefully, because here you might find some important information for future collaboration and support by others. And so that's a very important point as well.
Yeah, and Sven, actually, thank you for making that important point. I mean, one of the ways that I do this now is I ask people, how has COVID-19 affected your business? Because often people, they don't want to admit that business is going badly, or they're making a loss, or they're nearly bankrupt. This is, in some ways, it's a loss of face for them. So, and since they don't know you at the beginning, they're unlikely to come immediately with this information. But by offering the person an opportunity to say, well, you know, it was all fine until COVID-19, and then this made everything very difficult for us. I find that they're more willing to come forward with real difficulties that they're facing, because now everybody's got the same problem.
Yeah, absolutely. And also this might be an issue which you also better tackle in a private session. I mean, you can, if this were, for example, if they mentioned this in a common session, in a joint session, you can of course try to further explore. But I think, and as Gordon said, they will probably not give you a lot of information. But this you need to write down, and then you need to go back to it once you have started with the private sessions, because there you then really have to try to find also what's behind. You said that your company doesn't make any profit, no benefits. What does it mean? What's the financial situation? Or you start with the first question. It's a good idea. It's an excellent idea. So what is your situation now with this following the COVID in general? And then you step by step go into that direction. But this gives you a lot of useful information.
Yeah, and also reassuring people that it's not because they've got financial difficulties that you're expecting them to give in easily to the other side, because sometimes people will say, yeah, okay, I've got all these financial difficulties, but as a matter of principle, I'm not just going to let the other side walk all over me and do what they want. It's true that I'm not in the best shape financially, but still there are issues here of fairness and doing the right thing. So, I mean,
So what we then, let's ask them, Gordon, so now we have talked about this issue here. What is this opposition? What's the interest here? There were many interests, but what is one of the interests here of EVALIN? I mean, again, you remember we said we want to try in the exploration phase to identify the interests of each side. So what would be here the one very important interest of EVALIN company? Yeah, if resuming what Gordon and I have said now, and what you have read especially on the first page of the document, what's the core interest here of EVALIN? What is important for them? Yes, to protect their position, but that's very important. That's again a position, and you have actually written the word position. But let's go a step higher. Because again, and you will see in the mediation, once you have identified these interests, very often you will see that the other one has the same interest. So the potential of the Chinese market, yes. But again, what's the interest? Take it one step higher. Gordon, explain it. Then you think, take it on one level, on one higher level, more generic level. Yes, on a more generic level.
To expand their production line.
Yeah. So. Yeah. Exactly. So behind is they want the business, they want successful business. That's the interest. And the second one is the financial interest. Yeah, I think here they have the business interest, and then it comes to what you have written in the chat. No, they want the potential Chinese market. They want to irritate another party. They want to go into the vegan leather area. But the interest behind is, let's say, successful future business and the financial stability. Yeah, and because if they don't have financial stability, they will not be able to further investigate into the vegan area, and they will probably not even be able to continue producing as now, because they said they are not very profitable. Yeah, they don't do a lot of benefits. Yeah, so that's the interest, and you will see very likely the other party will have the same interest. And the advantage is now, imagine if we were in a remediation, we would have two flip charts. Yeah, and we would use one of the flip chart now, and then we would make a header called interest, and below we would write one of these interests. So future business opportunities, explore business opportunities for the future, and the financial stability as core interests of EBALI.
Yeah, and Sven, just to say that also we would be digging into, we mentioned that she says she believes there's a potential market for this vegan leather, and they need to develop the vegan leather further. So we would probably be looking to see whether they had got investors. It goes to what you were saying about the financial interest. Have they got a financial backer for this? Is there any, where's the money coming from? And is this something that's going to be really important about this mediation? Are they going to be looking for money in the context of this mediation? And if so, how much and what for and for what reasons?
And I think absolutely one. And I think you can also use this situation to transform, and that comes back to Gordon's third methodology in mediation, to use the transformative side. You also need to transform that the probably worrying or rather negative attitude to something positive. Yeah, because they said we don't make profits. We are worried because we really don't know how to further develop our business because we want to in the vegan leather. Yeah, and then when you try to identify the interests, which are neither negative nor positive, because these are neutral terms, business, financial stability, then you can also actually shift a little bit the focus they have. They might have a worrying and a bit, how do you say,
worried, yeah, they're concerned.
They're a little bit concerned, and you can actually try to by identifying the interest, to set already a step forward to a more positive scene, yeah, when it comes to the negotiation with the others. Good. Yeah. Okay, so then we have already two very important interests identified of EBALI. Then
okay,
what else
then we have a little emotional, potential emotional issue in that there's this allegation of bad faith, and which Evelyn says it doesn't understand about this bad faith allegation because the number 8 is simply a lucky number for Chinese, and you know it's very common to use in anything to do with Chinese, you know, Chinese articles or whatever. And so it was very natural for them to put the number 8 in their logo, and the heart simply demonstrates that it's for women. Well, you know, it's a product that was destined for women, and therefore they thought that the heart was a very you know, appropriate symbol to put in. I mean, on this, of course, I think the issue it raises, apart from there's obviously an allegation of bad faith might alert us to the possibility of a party getting emotional about that because it's been accused of something that's seen as very negative. The second thing is that the discussion about the number 8 and whether it's distinctive and everything, there's the risk that the lawyers turn this whole conversation into a dialogue about the legal rights and the legal strengths of all these trademarks. And while, you know, to some extent we would allow some space for a legal discussion, we don't want the whole mediation time getting taken up on hours and hours on whether the number 8 is distinctive in the European Union or not. And we have to be careful how we manage that conversation without making the lawyers feel that they haven't been heard or listened to. So we have to manage it in a way that takes account and recognizes that this is an issue, but we might say that it's unlikely that the solution is to be found in this legal issue because the parties just take opposite views on it. one party will say, well, number 8 is highly distinctive because there are hardly any Chinese in the European Union, and the other party is likely to say, no, it's not distinctive at all, because in fact there are quite a few Chinese in the European Union, and anyway it's something that's well known by Europeans or whatever, and we don't move forward. We're just getting anchored in a legal debate.
Yeah, and Gordon, talking about the lawyers, I mean, Susie said this, our colleague Susie said this morning, that the lawyer is the ally of the mediator. I mean, ideally it is like this, but to be honest, that's not my experience. It's quite the contrary. So I think what is important is that you need to try to involve the lawyers. You said this in the morning, Gordon. You need to be very cautious, because very quickly in mediation, people just go immediately to the parties and quite ignore the lawyers. And that's very dangerous, because don't forget, at the end of the day, the party together with its lawyers will leave the room, and then they will ask the lawyer, what do I do? Do I buy this settlement or not? And then if the lawyer has not been included the way he or she liked it and expected it, they will do thumb down, and then it's done. So the lawyers are absolutely crucial. You need to find a way how to balance, on the one hand, to make sure that this is about the parties and the business interest, but you also need to give a lot of room to the lawyers. And here also depends very much on the type of lawyer. You might have lawyers who are quite easy with this and they don't have a problem. They actually like it and might support you, but you might also have lawyers and even parties, because I remember a mediation where the party said, no, you don't talk to me, you talk to my lawyer. Yeah, and all the other way around, that the lawyer said, no, you don't talk to my client, you talk to me. Yeah, so and this happens in the mediation. So you need to involve and buy in the lawyers. Yeah, they need to really feel that they are part of it. They can address, and that's why also you need to address legal issues in the mediation. At least those ones we do here in intellectual property. Yeah, you need to have a moment where you also discuss a little bit the legal issues with the lawyers, because otherwise they will not feel part of it. And also then they will charge. And if they have not been part of it, and if they have not had the chance to express their legal views, they will probably feel very bad then charging the clients the day they have spent with you. So you need to be very cautious, and you need to be very cautious with the lawyers, include them into the process, give them room to express themselves, because at the end of the day, it's mostly the lawyer who actually say, yes, we buy it, no, we don't buy it. Yeah. So that's very important. And then Gordon, you said the emotional side here. We haven't spoken really on this one. I mean, usually in business conflicts, party always said there are no emotions. That's also not our experience. I would say quite the contrary. There can be quite high emotions, even between business people. Now, the question to you, if you see that there are emotions on the table around, I mean, with the people, how would you address this? So imagine you are now sitting in a private room, with you, your lawyer, and Gordon and I, the mediator, and you see that somebody's getting really upset. So how would you address this? What would be your strategy? And how would you deal with the emotions? Any ideas? Yes, let him or herself express. Absolutely. Very important. Because also here, you need to be aware of your own style. Are you comfortable with emotions and with stress and with also a bit aggression sometimes? And if not, you need to learn that you just address it. And as you have said, you just give the possibility to express it. And then you just recognize it. Yeah, and you just say, look, first you listen, you summarize. I see you are very angry, you're very worried, you're very concerned, and can you please give me some more information to understand it? And even if it's tough information, you can just say, I think it is absolutely okay to be emotional. I mean, it's not you. I think you don't lose your impartiality if you say that. It's something absolutely normal. So you give actually room, and this is also the role of the mediation, of the mediators, because if you see that there are high emotions, I think you need, in order to be able to move forward at a certain point in the day, and also to make it as effective as possible, you need to allow the parties to express their emotions. And even if it can be very tough, but if you help them to do it in a private session, you will see that this will have a very positive effect on the general process in the mediation. And then also to recognize, and you might also need to explore if this person maybe really needs to have an apology, for example. Somebody said this in the morning. This is something very important. I remember a mediation where somebody was so angry. There was a lawyer, he was so angry, and he was stopping the whole process. So I actually decided to have an individual conversation only with the lawyer, and I said, look, I can actually feel that there is an issue here. What has something happened here with somebody in the mediation? And then he said yes, and he was so upset with the other lawyer who was revealing confidential information to other parties he has sent him. So actually what he then really wanted, he wanted an apology. Yeah, and then I addressed it with the other party, and he said, oh, this was a complete misunderstanding. The other lawyer said, I thought I can send this to the other party. I didn't know that this was confidential. And so you see, it was a quite easy issue, but it was never openly discussed. So then the lawyer immediately said, okay, I'm really sorry for that. And then I asked him, okay, would you be ready for a short meeting, the three of us, and you just explain that, and maybe you apologize? He said, of course, no problem. And then he went there and said, look, I'm really sorry, there was a misunderstanding, and I sincerely apologize for that. And from that moment on, the mediation was very, very productive. And so you see, the emotion side can be, it's not always, yeah, but you need to be aware of, and you need to have techniques to address these emotional issues.
Yeah, absolutely. And talking of the emotions here, we see that Liu Li, he tells us that in fact he was employed by the Chinese company up until 2013, and that he says confidentially that he left the company because he found it quite constraining because of all the family connections. There were a lot of disagreements about how the company should expand, and because on the one hand, the CEO of the company, the Chinese company, thought that they should concentrate on China, whereas Mr. Liu Li didn't agree with that. And he also thought that he's trained as an engineer, but he was employed as a marketing manager. So we see here a history of some frustrations, and frustrations are emotions, and they will have to be managed if we're able to get the parties to work together in any capacity. We have to make sure that the errors of the past, so employing him in the wrong capacity, and also in this case, the expansion policy, that we avoid that's repeated, that we have a sustainable solution. It's no good just having a solution that's only going to last a few months. We've got to always try and work to find solutions that are sustainable and durable. We've already looked about the legal issues, and somebody in the chat quite rightly pointed out that the 8 figure is also an infinity sign, which would be weak in Europe. So again, it's unavoidable that the lawyers are going to have some discussion about this, but we would not shy away from that discussion, but we will try and not make it the dominant feature of the mediation, because we're unlikely to be able to find a settlement. That's not really going to find the route to a settlement is not through a legal discussion on whether 8 or the infinity symbol is distinctive. And then we see that Evelyn is also seriously considering filing a cancellation action against the earlier EUTM, and which we've seen with me before in the actual case studies, that this is a very common scenario, that there are these cross actions, and it's like reprisals. One party is saying, well, if you've hit me, I'm going to hit you back, and I'm going to make sure that I hit even harder than you hit me. And then we're on to an escalation of legal proceedings. So this is probably something that we would look at. With BATNA and WATNA analysis of reality testing, saying, well, yeah, okay, you're going to do all this it's going to be expensive. Is this really the way you want to go? Or what other alternatives could we find to that? And with the other side, if we're able to, when we do the Wagner analysis with the other party, also asking them about whether there are any possibilities of, whether they see any danger of escalation of the whole conflict. Sven, is there anything you'd like to add at this stage?
Yeah, I was just thinking, I mean, this escalation is an important issue. And also, if you see that there are a lot of parallel conflicts pending between the same parties, what might be useful is also to draw this conflict. I remember the case we did together where we had, I think, 25 or even more parallel disputes. And it was so complex that we even really didn't understand who was now suing who, at which office or which court. So what we did, we met one day before the mediation in the mediation room, and then we put wallpaper all on the doors, and then we actually draw with arrows all the different conflicts, which was very helpful first for us, and it had an impact which I would have never expected on the parties, because the parties came into the mediation room and they all saw these huge drawings and with all this conflict, and it showed the complexity. And then it also showed, and then we actually asked them, so you have so many conflicts. So the lawyers didn't even know all about these conflicts. And then we asked them, so what do you spend every year to run these conflicts? And then the bunch said, it was 500,000 euros every year. Now, okay. And then we started negotiation. Then late in the evening, when the parties started in a deadlock, to be in a deadlock situation, and then we always could refer to this drawing saying, okay, that's your alternative. Yeah, the button, this is your alternative. If you don't go out with a settlement, this is what expects you for outside. So you have a lot of disputes and you pay 500,000 euros every year on the different legal proceedings worldwide. And so that's very important. Okay, Gordon, I think before we move to the confidential information of the other company, do you have any questions, any remarks, any further ideas? Have you seen something in this confidential information which we have not addressed and which you think is also relevant? And what are your views? Just let's discuss a little bit. What's your? Do you think that we have addressed all the issues and in this confidential information? Have you seen more? Do you have any ideas, further ideas, or techniques you would use? It seems that all makes sense to you. That's good.
Okay, Sven, maybe we. Is one more reason for mediation not to make much noise, bearing in mind that the signs at hand do not enjoy strong protection? Yeah, that's actually a fair point, that sometimes you can subtly draw the parties' attention to the fact that if they continue to attack each other on a weak overlapping element of the mark, they risk actually mutually destroying themselves, so that nobody wins. It's a lose-lose situation, and that's something that when reality checking, which is another technique that mediators use, that you would try and bring to their attention, without, of course, giving legal advice on the matter.
Yeah, that's an excellent point, and that reminds me of a case where I was in a really tricky situation, because I remember that both of them had really absolutely useless marks, to say that, where they had no scope of protection. They were both pretty descriptive, and one was saying it, but the other party didn't then say, okay, but you have the same, your trademark is also nothing, so we are in the same. And then of course the other party was completely silent on that. And then of course I was looking to the lawyers and said, look, I mean, you should do the same. You should actually say, okay, if you don't find a deal here, tomorrow you have a cancellation action on your table. Yeah, I mean, of course, as a mediator, I could never say so, and if I did, then the mediation would be done, because of course the other party would clearly object to me as mediator. But it's also sometimes difficult, because you can see that not all the lawyers really control the procedures of these issues. Although the trademarks, it's not the most difficult legal area, but you need to understand the legal constraints, and you need to be aware of this, because to be honest, what you could do in such a situation, you could maybe go in a private session and with a lawyer only, maybe even say, look, I mean, you say that the other mark is not very distinctive, but maybe it's not, it's also the case for your one. So maybe the other party is not addressing that in the mediation, but who gives you the guarantee if you don't find a deal here that tomorrow they find a cancellation action? So again, here as a mediator, you need to be very creative how you can actually introduce these issues in the mediation without losing your impartiality, because of course you could never say that in front of all the parties, but you could maybe do it in front of one of the lawyers. Yeah. Good.
Okay. Sven,
Any
we
further?
better move to the second set of confidential instructions, which are this time concerning the Chinese company Xuanxi. So what we learn is that the managing director is the great-grandson of the founder. I mean, that information may give us some indication of the sort of respect that that person believes he's entitled to when addressing him. So we have to be very conscious of that. And also, we find that Mr. Li, of course, we knew that he was employed in the marketing department of the family business, but also that he's in fact the nephew of the second wife of the managing director. So that information may tell us, well, what do you think, audience? How do children of second wives, how are they usually perceived by other family members? What are your thoughts on that? What might this mean in his relations with the other family members? Well, that's a good answer that somebody's given about. It depends on the families and the stereotypes. But well, yes, that's a very fair point that I'm probably wildly stereotyping here. But I think in many instances, it may be that there's some tension because they see this person as a newcomer in some way, less entitled, let's say, to the benefits of the family, and that's maybe something that we need to bear in mind. But hopefully, we're proved completely wrong on that, because, as you say, it's just a stereotype, and these are very understanding and open-minded people. Okay. We also see that the Chinese companies family-owned, like the Spanish company, so that's something they've got in common, and that they're exporting homeware and bed linen. So, as one of the interveners said yesterday, earlier on, that this is quite different goods essentially to the ones that Evelyn's producing. And they've recently started doing business in the European Union, the USA and Australia. So there's some overlap in the European Union, perhaps. USA, the Evelyn's not so worried about, because it's doing commission work. It's not looking to impose its brands. And Australia's completely different. So again, territories, this goes to, could these rights coexist without running into conflict in certain territories? And therefore, do you need different solutions depending on the territory? Because sometimes you might not have one solution that fits everything. You might have to come up with 3 different solutions depending on the territories in question. They are diversifying into clothing and jewelry, and they're planning to enter the leather goods market. So again, as our intervener said earlier on, these may be areas where we could explore cooperation between the parties, so making the pie bigger. Then there's a paragraph about the history of the company, which will just mean that we have to be very aware that they're going to usually in those circumstances want to be treated with great respect. They're going to consider that their trademark commands a lot of goodwill and is prestigious, and also has to be treated with the necessary degree of respect. So any solution of working together, they're probably going to want assurance that their trademark is not going to be damaged in any way, and they need to be convinced that it will that they're going to gain benefit from this. We also see that they have a store in their landmark store is in China, in Shanghai, and they have a lot of brands internationally and in China, and they've started selling in the EU and London. So again, that goes to the overlap. Yeah, it's really about the importance of prestige and tradition, and also we have to be very aware here of cultural considerations here. How are Chinese people thinking on these matters of their traditions and their prestige, and how might this affect the way that the negotiations are conducted and the sort of language that we're going to use when addressing each of the parties? And also, I mean, one of the things about when you're in a bargaining phase is that you need to sometimes reformulate the offers to, like Sophie was saying, that perhaps if you had the word damages, you would want to say a settlement payment instead of damages. This sort of language will be very important where there's a different cultural context. So we're going to have to be very careful and very thoughtful in the way that we formulate everything. Sven, would you like to add anything in there?
Yeah, maybe as a last point, Gordon, and then we can close this and we can open the floor for last questions. In the last two paragraphs, you will see that Stephen Yan, for him, it's very important to leave the company, let's say, without any free of problems, as it said there. Yeah, and also here again, you could explore what that exactly means, and then if he wants to really pass over his company to his son, the company without any pending conflict, that would of course also be a strong argument then for the negotiations to find a settlement with the other party in order to avoid that his son inherits not only the company but also this conflict with Evelyn. So this is then of course something which you need to explore, to need to understand, to see the options, and then again this would be probably a good reason then to agree and try to find a compromise. And as a last point, if you allow me, we haven't said that what is also very important, and that we always do it, coming now back to the beginning of mediation, before parties engage in mediation, I personally make it always very clear to the lawyers, and if possible also to the parties, that this is a win-win. Yeah, and you cannot go to a mediation if you're not ready to give. It's win-win and give and take. And it's win-win and give and take. So you can't go to a mediation with the attitude that you want to take, but you want not to give anything. Then I said, because if you don't have to tell me where you are ready to give, yeah, but you have to very clear that you have to give something, and you have to give in. It's impossible that you get everything you want. And if you are not ready to do this, don't engage in mediation, because you're really wasting time, my time as a mediator, and the time of the lawyers and the parties. So it's very important to actually make very clear at the beginning, you know what mediation means. It's a give and take approach. So you will get a lot of things, but you must be ready to give things as well also to the other party, because otherwise it doesn't work.
That's okay. A very important point, Sven. I mean, just to give you an example, that last year I had an American party who a big corporation, and they said a very unfortunate remark, which is, this mediation's over when we win. Of course, that was a mediation that I was not able to settle because the attitude was completely wrong. They weren't prepared to give anything. They saw giving as a sign of weakness, and it doesn't work if it's done like that.
Okay, so before we hand over the floor again to our dear colleague Kirsten, we would have a couple of minutes for further questions, remarks, comments, whatever. We have a question here. I'm wondering how mediators with certain cultural background are dealing with parties from, I assume, quite numerous jurisdictions. Any advice? I mean, you have to have an open mind, and you have to understand the different cultural backgrounds, as Gordon has explained. Yeah, and I can give you an example. I did once a mediation between an Italian and British, which I would say the cultures are not so different, but they are, because for the Italian it was so important. And he told me, I want to bargain. Yeah, I want to go. I give euro. No, you give me 2, 3, 4, 5. And he said, I want this. This is my way of negotiation. And the Brit said, I give you one number, and this is the number I will give. And there's no bargaining here. I don't want to bargain. It's not my culture. Yeah, and here that's difficult. You have to then explain it. Look, okay, then maybe start with a lower figure so that you can go up a little bit, at least that you can try to reconcile the different styles. Yeah, I don't know, Gordon, if you have. I mean, in jurisdictions, of course. I mean, you can't know about all the different laws, and you should definitely refrain, in my personal opinion, of giving any legal advice, in particular if it's not your jurisdiction. And again, for me, it's clear it's not the role of the mediation. Again, you need to discuss legal issues, also to include the parties, but then, to be honest, you can't go further. It's not the role of the mediator.
Yeah, I would just say that with the cultural considerations, I mean, you try and inform yourself as best you can about other cultures. You have to be careful, of course, not to stereotype, as we saw from the last question. I mean, you could have somebody, you may think somebody from the Middle East has certain ways of doing things, and it turns out that that person was educated in the United States or in Europe, and is very offended if you stereotype them as somebody from the Middle East in a certain category. So you have to also be aware of your own biases, what the psychologists call the cognitive bias. We all have some biases and prejudices. It's part of being human. What's difficult and what we have to strive to do is recognize that we have them and try and manage them as best we can. I mean, there's no perfect solution to this because we're human beings, but if we're aware of these things, I think it takes us quite a long time. And I think by asking the question that the person that asked did, that's a very good start to show that you're aware and willing to learn and understand.
More questions?
Maybe Sven, I just got, while we're waiting for a question to come in, I would just say that in this, going back to the case, there's a sort of older patriarch of this company and a younger son. One of the issues would also be that we mentioned earlier, having the right people at the mediation table, or, you know, virtually, because maybe we need this patriarch and the son there because they both want to take decisions. They're a bit like the husband and wife. You can't do without both of them. So I think one of the things that's often challenging is getting the right people to the mediation, because people tell you when they're high up in a company, you know, it's like making an appointment with the Pope. It's not going to happen, but you have to try and do your best to convince them that this will give the mediation the best chances of success, because it shows that they're concerned and they're looking for a solution.
Gordon, I think it's 6:30 if I'm not wrong for you.
Yeah.
It's Friday. I think we leave it here, and it's of course you can contact us at any time. Just to let you know that we appreciate it very much to be again with you. I mean, some of you will remember that we visited your office in 2019, Gordon. I think it was or 2018. I think it was 2019. And sorry,
18.
18. It was 2018. It was a great visit because Georgia is a great country. We had a lot of interesting meetings with you, and we saw some really nice things of your country. And yeah, we wish you all the best. Have a nice weekend, and then we pass the floor now to Kirsten.
Yeah, thank you.
Thank you, Gordon and Sven, for this excellent example of EUIPO mediation in practice, as well as, of course, for the guidance through the challenging questions and answers, and for making this session dynamic for a Friday afternoon.